the choice but to do so. See how that's different without bringing up anything outside of that, and it's still a good opening statement
Yeah,
with
yeah, I get it, except for
transparency.
the fact where you said stab. But yeah, I get it because you don't want that in it, even though that's all true facts what you said, and even though that's very creative and good, actually framing, right? But you don't
Mhm.
want to say stab because that's going to put it in the mind of the jury, and that's going to have an unfavorable outcome. But this is the thing, right? We have to admit, right, that again, if the judge says, if they go before the judge and they say, Judge, he's saying that I broached the agreement. Is this a breach of the agreement, Judge, from your understanding? And the judge said, no, from my understanding, it's not a breach of the agreement. Then that should be what it is.
I have a question. Does he talk about in this 193 page thing what that argument was exactly about? Does he make statements on what was said?
Yeah, well, so to speak, right, Uda? Because basically the argument was the fact that the argument came when the judge basically when the judge was like, yeah, it's not a violation, but when the DA kept bringing it like, yo, you violate, and then the judge was like, well, listen, it's not a violation, but truth be told, there's nothing legally I can do if he decides not to keep up with the agreement. That's where it kind of went off the rails.
Right.
Yeah,
So
that was
if he's not, I'm sorry, Uda, I'm gonna say this and then you got it. If
yeah.
if Mike Howard is not going to keep to the agreement, then I'm not going to keep to the agreement. Y'all see, this is why I was making that argument on your show.
Right, but according to the judge, he did keep up with it. See, the judge is the arbiter of that. And so,
Right.
according to the judge, he did keep up with the agreement. It wasn't a
Got you.
violation of the agreement, but
No, I'm
he
talking about the
can't.
prosecution. I'm
Right,
talking about the
right. No, no,
prosecution.
no, right. No, meaning that the defense kept up with the agreement, but the judge cannot enforce it if the prosecution decides to renege on the agreement. That's the basic point. That was the basic premise, and that's what put the Carmelo Anthony actually testifying in jeopardy. That was
No.
the
Okay,
thing.
but
Go
check
ahead, baby.
it. Oh no, it was supposed to be Uda. Uda can go and then I'll
Uda,
go
go
after.
ahead, Uda.
If you
Uda,
can,
you
you can
there?
take your game, bro. I'll go after you. Yeah, bro.
Thank you. I just try to keep, things in order. But here's the thing. Once Mike Howard knew he violated the agreement, right? And he already opened the door, even a little bit. At that point, he was supposed to say to himself, all right, we in here to fight dirty now because we done already pulled it, right? Because that was a little slick stuff. So he should have been very aggressive at that point, knowing what he was going to be up against when he started to present his case. He should have been very much objecting. He should have been very much cross-examining those young people very firmly and aggressively to call out their lies and not giving the prosecution the opening to make him look a complete and total fool. And he should have prepared his witness, Carmelo Anthony. Listen, I'm about to turn it up. I'm about to turn it up. So let me prepare you, your mother, your daddy, your auntie, your cousin, and whoever else we got on this list for a brutal cross examination because I'm going to gaslight them to think that they're coming into this easy and they're going to go back hard on us once we get on the stand. Because if you bring a neurological expert to the stand, sorry, no matter how hard you try to come at them on cross examination, you can't argue medicine. If you bring a mother, if you bring a mother on the stand, no matter how hard you go against her and cross, all she's going to do is cry. You understand what I'm saying? And with Carmelo, what was actually effective for Kyle Rittenhouse was on cross. He was brutalized. He was brutalized. And he held his frame. He cried a little bit. And them tears is what brought him his freedom.
Yeah.
Right, you're right. But this is, I'm sorry. You're right.
I would have set it up just like that. I would have let the process, even if I would have let the prosecution have an easy case, I would have flipped the script and put Carmelo on. Because then if you go hard in the paint in front of the jury and I didn't go hard in the paint on your witnesses, now you look crazy. That weakens the prosecution's case.
Well,
But
it could.
Hold up, Izzy, hold up, Izzy, hold up.
Deal initially because that whole deal from the beginning limited all of those things. Even when the mother was called, right? Because the mother was called before the sentencing, right? That's the only time. But even she was limited to even the questions that they would ask her. She could only testify that that's my son and please have mercy. That's it. Nothing further. All these parameters were set. All right. So even for him to even speak about why he had the knife, for him to speak about he was scared would have also breached the agreement and opened the door as well. So this whole agreement from the very beginning limited all of those factors. The defense planned on cross-examining witnesses and even making them hostile witnesses if they had to. The defense also planned on calling Karmelo Anthony only after they called their other witnesses, and they was going to call him last after they built their whole case, right? So all of these things fell apart because of the same said deal. So they're still trying to keep it real to this said deal when Mike Worski, who created the deal, is not even keeping it real to the same deal that he created. So it's not like the defense created this deal. The prosecution created the deal. I don't think that they should have ever entered into an agreement with the prosecutors. I ain't never know the prosecutor to ever love no defense. That's just period. That's what I've seen in my whole life in the court cases and shit I've seen in my life. But hey, that's it. But I think just the agreement from the very beginning limited all of those factors. He came back to say, yo, I didn't even think your client was going to testify. When everybody know, even a layman lawyer knows that in a self-defense case, the person that's in the self-defense case, the defendant must testify. So as a prosecutor, you were a lawyer way before you even became a prosecutor, but now you acting like you don't know what the hell's going on in the case. Like, come on, stop, bro.
Yo, can I say this real fast?
Yeah,
real fast. So first best Gigi is saying that if the judge said the defense hadn't violated agreement, then the prosecutor could not violate it himself. That's not true. And that's what the judge was saying. The judge said, hey, look, he did not violate that to the prosecutor. It was not a violation, but he turned and said to the defense, hey, look, you did not violate it. You're right. However, if he decides to go down this path that he's threatening to go down, there's nothing really that I can do to hold him accountable legally for this. So he was letting him know that, yo, you're right. You're right in what you're standing. You're right in what you're saying, defense, but there's nothing I can do legally to stop him. So you have to know that, and you have to let your client know that from the beginning, and you only have 10 minutes to do so.
This is true, right? But here's the thing. Here's the thing about it. This is on the parents ultimately, because I want you to picture it, Sicily, 1933. You paying somebody, and somebody says to you that you're paying your employee. I'm not going to give you 100% because I done made a sideways deal with the prosecutor. Let's be very honest. This case played out how the prosecution wanted it to play out. Right? Which means, what am I paying you for? We could have had a public defender. That could have been $75,000 still in my pocket. So it's on the mother and the father for accepting that defense in the first place. That's number one. But number two, the judge can't make him not go hard on Karmelo on cross, but Mike has the ability to object. Let's say the quiet part out loud. Mike was just being lazy. He didn't want to do the job, and the parents were being foolish as hell.
Yeah, I think he was just being plain incompetent, to be honest. But yeah, I mean, I get it. He was being plain incompetent. But I would say this. This is what I would say. I would say it's beyond an uphill battle when like you said, you have 21 witnesses, a lot of which had different statements. There was a lot of information that wasn't brought to the table because of this agreement. And then at the end of you letting all this stuff slide, you letting all this character, you letting it go by as if Austin and Hunter were these good kids and nothing was wrong with how they behaved and how they act. And then you let the prosecution ream Karmelo. Yeah, I don't think that would have went over that well. And I think he probably would have got more time, to be honest.
Do y'all mind if I read what happened on June 8th right quick? Because that's the crux of where we at, right? So the final day of evidence after the defense has spent voir dire, is opening the entire cross-examination of the state's case, and the first day of its own case, honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant, and asserted that defense counsel had already opened the door by mentioning and opening that the defendant played chess, a position the court itself rejected. So the court, like y'all said, because this is my first time reading this, the court agrees that the defense did not break the agreement. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding. An understanding that throughout the months the defense relied upon it existed on no record because it had been reached and presented to the court off the record. That's bad. You're now resting your case on the prosecution's bad case.
Facts.
That's not good. That's
At
terrible.
all. Exactly. Horrible.
But here's my problem. And I'm glad that we come to understand it. But here's the problem. You open the door, hold on, wait. Let me finish. Even if the judge disagrees, I can disagree with the judge and then say, you know what? You're right. He didn't break the bargain. But he's going to put his witness on the stand, right? Okay, cool. So I'm not going to break the bargain either. Wait. I'm only going to talk about that. Go ahead, baby.
But he's not. That's the problem.
Wait. Because the defense attorney also has the right to redirect.
Absolutely.
So saying that this agreement went south or whatever is inconsequential because he could have called one of the witness back to rebut and to redirect.
Even after they closed their
yes.
After they closed their argument down. Are you sure about that? Because I thought the prosecution would be able to do that, but I don't think the defense, being that the burden of proof is on the prosecution and not on the defense, I don't think in this particular style case the defense could have redirected after the prosecution already they would have had to do it before the prosecution closed their argument. That's the point.
They could have called the rebuttal witness. It
still was limited by the constraints of the deal, because the deal was not to go to character evidence, extraneous evidence, all of these different things. So I think that was still limited. That's how come the defense got off their case as clean as, the prosecution got off their case as clean as they got it off, based on the same deal. So that's where it's the prosecution. Who's going to trust them? So if you trusted them, that's your own fault. It's some foolishness for you to even trust them. But, I think the prosecution did what was good in their best interest. Why would they want to be looking out for the defense? So
right, the deal is totally relevant. The deal is not irrelevant, y'all. The deal is totally relevant to the fact of why he got inadequate defense. It's totally relevant.
But the deal is relevant.
But hold on, wait.
Because that's why Karmelo didn't testify ultimately, because even the judge said, look, man, if you go in, you may be even now at the end. Now when they're talking about they're going to call Karmelo, which they've been saying through all these meetings that they were going to call him as a witness and as the last witness. Now, later now, while Bill Werskey's bringing up the argument that he even broke it for the chest thing. Now they get into a conversation where he's saying, now the judge is telling him, Judge Roach is saying if you call your client now, for your client to even say that I had the knife because of this and I was scared, then you would also be opening the door. So even when he was talking about bringing up the coach, and he said, what would the coach testify to? That's not about character evidence. And then he said the coach is just going to come and testify that he witnessed the seizures because he's seen them and stuff like that. So it's not about the character. It's just that he witnessed the seizures and that. So ultimately, when they went into the back and forth, even about that, ultimately, they didn't even call the coach to even talk about the seizures. You see what I'm saying?
Gotcha.
So this deal was based on all of those things. It factored into all of those facts, bro. Trust me.
But really quick, I just wanted to read this right quick because Gigi raises a point. Gigi says, enforced, there was no paperwork on the agreement. If there's no written record, there's no way to bind the parties to it.
Right. That was the point at the end. That's the truth.
Right.
But
so
the
if there's
created a motion in limine just to substantiate it, this is what they made the defense do.
But when did they go ahead?
Where is the motion of limine?
Allegedly, it was in the beginning.
This is what they did. This is what Mike Howard said in the affidavit. He said so because remember, the judge ain't tell him at that time that he couldn't bind it and all those things, which he probably knew that he couldn't bind it, but he never went into those things then. The only binding time was later on when the whole discrepancy happened. But
I don't
after
think
they
you're
came up with the
understanding.
agreement and they went in front of the judge, I'll bring it up and show you. I'll screenshot it to you. So
Yeah,
after the
yeah, show it
judge,
to me.
I'll bring it to you. So after the judge and him came together, you know what I'm saying? And then they said, we drafted a motion in limine and all of these things to, I guess, to have something substantiated because it was just all verbal. They were talking on the phones about this deal while they were solidifying multiple times on the phone. So I'm gonna bring up that wild cell read or whatever. I'll try to find that for you. I'll show you.
So really quick, oh, that's what I was reading. All right. So an understanding that throughout the months the defense relied upon it existed on no record because it had been reached and presented to the court off the record, and that if the defendant testified, the door to character and extraneous offense evidence would almost certainly be open. Allotted 10 minutes, the defendant elected not to testify. By then, somebody has a banging going on. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witness. And at punishment, the defense case was reduced to the 3 pre-approved questions of the defendant's mother. The state, for its part, called no punishment witness and offered none of the extraneous offense or character evidence cataloged in this 75-page notice. Did I read this already? Hold on.
Nah, but that was for the, you read the other part. But see, this is the thing. Can you hear me?
Oh, wait, yeah, I did. Wait, hold on. That's my fault. I did read that already. My bad, y'all. Hold on. I got to get to the part where I didn't read. The case of June 8th and find out the evidence. Open the door, never contemplated, and the party, vibe, understand. Oh, so they just repeated it. Ah, there it is. All right, so this is the new part. All right, so I'm going to go back a sentence. Right here. On June 8th, on that final day of evidence, the state asserted for the first time that the defense had opened the door in the opening statement and that the understanding had never contemplated a testifying defendant. And the court advised the parties that it had no mechanism to enforce the understanding. It would rule under the rules of evidence alone. Faced with that reputation, the defense abandoned its plan to call the defendant and to present certain expert testimony. The state's own conduct then corroborated the understanding it had just denied. At punishment, it called no witnesses and offered none of the extraneous offense or character evidence cataloged in the 75-page notice. Resting its punishment case immediately, precisely as Mr. Worski had described on May 11th, the agreement would operate. A matter the reporter's record will confirm. The state's punishment presentation and circumstantial evidence from which the court may infer the parties' shared understanding. At minimum, it is a fact that should be explored at the evidentiary hearing. And the final ledger confirms that asymmetry of the breach, neither side ever introduced the character evidence that understanding covered. The state's forbearance costed nothing because the defendant, silenced, never opened any door. But the defendant didn't have to be silenced to open the door because you, as the representation of the defendant, which is Mike Howard, you opened that door.
Why but he didn't. If the judge said that he didn't, then he didn't open the door, bro. That's the whole thing. Y'all don't know why y'all don't understand
it. Claim from Mike Worski trying to
be
slick.
Trying to be slick to put some salt in the game.
He got caught with his hand in the cookie jar because the judge himself, the man in this trial, said no, that's not true. He didn't breach nothing. So that was just a claim that the prosecutor was trying to be slick with. The judge
I agree with you.
I'll bring it up and show you that the judge said that. He said, no, it's not, bro. So it doesn't matter what he said with that because it wasn't true.
Right. And I agree with you on that. But then if we're still sticking to the agreement, you're going to put Karmelo Anthony on a stand. Because wait, hold on. Per the agreement, if you don't bring up the Metcalfs and I don't bring up his character, Carmelo's going to testify.
Okay.
Wait, hold on real quick, bro. If I can say this, that's not true, Sel. This is the problem. The problem was as soon as he made it known, okay, now I got to bring Karmelo up out of order. So I got to bring Karmelo up on Saturday instead of Monday like we planned after everything was said and done. And that's when the prosecution like, what? Nah, he's not. nah, if he comes up, we're gonna treat him like a hostile witness. And I'm like, wait a minute, our agreement
No,
was
he
such.
told him, I didn't think about. He said this
Right.
agreement
But
didn't
hold
plan for
on.
your defendant to come and speak.
I
That's what he
got you,
told
but
him.
I'm saying the same thing in a different way. The point that I'm making is that, so basically this was a threat. This was like, yo, if you put him up on the stand, we're gonna eat him up. So that in turn messed up his whole defense, basically, because his plan was to bring Karmelo up knowing that they wasn't going to talk about his character, knowing they was only going to talk about the events of April the 2nd. But when he flipped on the agreement and he said, yo, if you bring him up, because we didn't think you was going to bring him up at all, like Uda is saying, then that's what deterred them from bringing him up. And since they didn't bring him up, that's what he's saying. He basically kept with the agreement. So the thing of it was, he just did that to put salt in the game, to keep Karmelo from being able to testify, or to put the fear in, if Karmelo did testify, he was going to breach the agreement. That was the point.
Hold on for a second. Hold on, Uda, because Raw was trying to talk. Go ahead, baby.
Yeah, sis.
Just skip down to page 135. We could just read his affidavit.
Page
I got the
135.
thing for you in the back too. When y'all ready to
Is that page 135?
Yeah, Oda, you got 135?
No, I remember I got the page to show you the lemony thing, but I got all of that. I got the whole document.
Okay.
I got the lemony things screen shared in the back when y'all ready. But I was just saying
135.
Yeah. Right. I was just saying though, it went so much an agreement that the defense had to go line by line of what he would go through with Karmelo Anthony. And when do you see a defense go to the prosecutor and they go in line by line what he's going to be doing, his defensive strategy? And Bill Werski was standing over his shoulder looking line by line of what he was going to go through.
It's called discovery.
Yeah, that's discovery.
No, that's not discovery.
That ain't discovery. We talking about
discovery, y'all.
No. Discovery. This is off the record.
That's not discovery.
Wait, hold on. Motion and lemony comes in after discovery.
I'm not even talking about lemony. I'm talking about with the kids when it comes to
right. He's talking about his actual strategy of exactly what he was gonna ask Karmelo, how Karmelo was gonna respond. He had to go through that with the prosecutor in order for the prosecutor not to trip. And by the time he got to Karmelo was like, nah, I don't feel comfortable. And so that's why they, in the 10 minutes that he had to revamp.
But here's first of all, go ahead, Raw, because y'all did cut Raw off while she was speaking. Go ahead, baby.
So anyway, what I was saying is, it's discovery. In discovery, you got to give all your facts of the case to the other attorney. You have to. You don't have to tell them how you're going to use that, but you have to give them everything. You have to give them depositions, and everything. You have to give them your exhibits, your pictures, and everything. That is discovery.
That's the
but before we read his affidavits, let's look at the motion of limine, because even in his affidavits he said there's no motion of limine on the record. So let me see.
So look, it said, we agreed that the best way to document such of an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses, so it would cover both the Metcalf twins and Mr. Anthony, but if made public would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. So I drafted the motion in limine as described above and sent it to Mr. Werski by email, and it was hand delivered to the judge on the opening day of trial. So I'm saying,
but
so
wait, let me read that. We agreed the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So in other words, he covered up a backdoor agreement by filing a motion in limine. That's what this is saying.
Exactly.
Right?
Yes.
Right. But that's the problem. Wait. Hold on. That's the problem.
It wasn't a problem.
Wait, hold on. Wait. Listen, I'm reading.
Come on, then. Read the whole thing. Then.
Hold on. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During the meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous, I got to make sure I read that correctly, extraneous evidence as it applies to both sides during both guilt/innocence and sentencing phases, as long as no doors are open or false impressions given. That's in quotations. We agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous. Is that extraneous? That's extraneous.
Extraneous
evidence applicable to. I'm doing that for. If y'all haven't noticed, I'm doing that for a reason because I'm getting ready.
Because you're an asshole.
Yes.
Go ahead.
Well, no, because I'm getting ready for something. You know what I'm getting ready for. That's what I'm going to school. So we agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony. But if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. So I'm gonna make sure I got this understanding, and y'all can tell me if I'm misunderstanding this. As long as we don't mention it in public, it's a fair trial. Yes?
No. But no. But that's the thing. That's why it's shady, it's unethical, and it's bullshit, right? Because at the end of the day, it's so really what it's saying is, as long as we don't mention it in public, it will not be under scrutiny, and it cannot it cannot tamper with the integrity of the trial, so to speak. Even though this is an integral thing, because they have to do it in the back door, they have to do it in the shadows, and he has to do. That's the good faith. That's basically the good faith omen to show, hey, look, I'm showing good faith by doing this because I shouldn't be doing this. So that means that I'm gonna keep my end of agreement. So I'm expecting y'all to keep y'all end of agreement as well.
Okay, cool. Now, I appreciate that. Now scroll down a little bit. Defense's understanding of the agreement. I want to read that. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description by Mr. Worst described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language, Mr. Worst repeatedly used the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would on any other eyewitness to the incident under the tent on April 2nd, 2025. Following the plain meaning of Mr. Worst's words in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses, such as the memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. So the defense was under the impression that they viewed Karmelo Anthony as a witness. Am I reading that wrong?
No, you're reading it right.
Okay, this understanding of the agreement was further confirmed by
the defense.
No, the prosecution.
No. See, that's
go back up. Wait.
Hold on, Sal.
Go back up.
Hold on, Sal. Give me a second, because I caught something.
Because they saying that.
Hold on. Uda, give me a second. You said the defense, and I said you're not reading it wrong, because it is the defense understanding. So this is the problem. When it came, this is upon hindsight. You got to remember that this is after everything was said and done. So when it came to when they was gonna put Karmelo on the stand, the prosecution made it seem like they never had that understanding, which is the whole problem to begin with. So that's the thing.
But here's the problem, and Gigi nailed it right on the head, because that was exactly what I was about to say. It's not preserved. Everything that you want seen in an appeal, you have to preserve it in evidence. This motion of limine does not talk about the agreement. It talks about characters It talks about witness, and it talks about what's the other thing that it does? Talks about expert witness. That's what it talks about.
Extraneous, whatever evidence.
Right.
Yeah.
So this agreement that they had will not hold. I'm sorry, it won't, because it's not preserved. You covered up an agreement by using a motion that had nothing to do with the agreement. There's nowhere. Wait, hold on. Wait. Listen, I'm reading the plain language that I'm seeing in front of me.
Yeah, and that's why he got railroaded, and that's why
by his own attorney.
Yes.
Wait. Hold on. Wait. But here's the problem.
But the train tracks was created by the prosecution.
Hold on.
Train tracks and the lack of stop sign.
Hold on. Here's the problem, and I need y'all to look at this as if you were an appellate judge. You're looking at this with no bias, and you see, a motion in limine. Well, let's look up what a motion in limine is. Bang, we look it up. All right, cool. He filed a motion in limine. We can't talk about character. We can't do this. We can't do it. Okay, cool, no problem. So let's read through the case. We read through the case. Well, the judge said that nothing was broken, and okay, cool, no problem. Now we get to this affidavit or this statement where he says, well, actually, this is what actually happened. And you agree to this months in advance?
Yes.
Yeah. But look, Karmelo Anthony. Well, hold on. We're quick and down. I'm gonna pass it to Raw. Yeah, Karmelo was railroaded. You know who put him on the track? Mike Howard. But you know who hired him? Anthony's family. He don't get it. Wait, because I'm passing it to Raw. He don't get a retrial because the prosecution fucked up. He don't get a retrial because the judge fucked up. He don't get a retrial because Mike Howard fucked up, because an appeals court is if the court fucked up. Go ahead, Raw. You got it, because I'm gonna step away for 1 second.
And then let me go after you, Raw, please.
Now he gonna step away while I'm talking.
I'm just getting some water.
Jesus Christ. The point that I was saying is we really need to get to this man's affidavit, because Mike's affidavit talks about a gentleman's agreement, right?
This is it.
No. That's not it. That's a narrative. This
is all part of the affidavit, though. This is a.
Wait, hold on. Let her finish. Let her finish so we can see where she's going.
I'm making sure that Raw knows that this is the document. I'm just making sure Raw knows that.
But she's not going there. Let's hear where she's going.
So what you're looking at is the narrative that the appellate counsel is putting together based on the depositions that they took, that they included as articles in this case, right? But when we actually look at his affidavit, in his affidavit at point 5, he says Mr. Werskirski referred to it as a gentleman's agreement. We're dealing with matters of law. Who's talking about a gentleman's agreement when we are talking about the law? So we could go ahead and kick it back and forth, kick the bobo until Sale come back, because I want us to go through.
I'm back.
Okay, you're back. Good. Go ahead, say what you guys say.
Can I say this? Oh, wait. I asked for next real quick.
First Izzy, then Uda, then we're going to pull it back.
Put ice in that water, Sal?
Hell yeah.
Hey, let me hold on real quick. Let me just say this. This is the thing, though. Legally, this is a fix. Legally, this is damning and damaging. They literally, think about that. The defense filing for limine is really an admission of no defense at all. Because if they're not talking about the character of Karmelo Anthony, good or bad, good in the defense, right? If they're not talking about the character of Austin and Hunter, meaning bad or things that would substantiate their argument, Karmelo didn't get a defense at all. He didn't get a defense. Like he said, he didn't get a defense. And so he was entitled to a defense, and that attorney was supposed to do everything that he can fervently to defend Karmelo. But he made a gentleman's agreement, quote unquote, to not defend Karmelo at all. That is negligence. That is criminal. That is unethical. And absolutely, even with him saying it himself, that absolutely is going to give Karmelo another trial, bro. I promise. Watch what I tell you. That in itself, all of that in itself, because again, the judge signed off on, agreed to it. The DA agreed to it. And even if we say we don't believe him, what was that 3-hour break about? What was all the us waiting to see what's going on? What was the fact that the judge was rushing the process and literally said that he wants to wrap this up on Saturday?
Right. So this is the thing, right? The judge wants to wrap it up because this was a high profile case and there was too much stuff going on in his town and in his city, right? That part we all can agree on. However, pick the part is right. You can't get an appeal based off of bad strategy. However, what this attorney is doing right here, like how I said, he's making unsubstantiated claims. Now we're going to read through it. We're going to talk about it. Okay. So he says, I'm Mike Howard. I'm at least 18 years of age, of sound mind. I am competent and qualified to make this affidavit, blah, blah, blah. I was trial counsel supported by second co-chair counsel, Toby Shook, third chair, Tasha Gupta, and a briefing appellate co